So the Sunshine Law is in a state statute called 286.011, and it provides the right of access to state and local government meetings by citizens. There's also a reference to that law in the Florida Constitution at this point. The law applies to any gathering, whether it's formal or casual, of two or more members of the same board, committee, or commission, at which they discuss a matter which will foreseeably come before that board, committee, or commission for action. Now, I'll go through examples later, but essentially, whether you're meeting, privately, at a restaurant, in any location whatsoever, you're allowed to do that as long as you're not going to discuss any matter that's going to come before that board for action. So that's always the key. So people are still allowed to be human beings. They can, have lunch together. They can go to a play together, but you're not supposed to discuss anything that's going to come in front of that board. And the courts have interpreted the law to apply to more than just a final decision-making body. So if you have a committee, for example, that's involved in the decision-making process, the meetings of that committee would also be subject to the Sunshine Law. So what are the basic requirements? The meeting must be open to the public. Obviously, we're all aware of that. Public attends. They can record. They can videotape the meeting. Inaudible discussions among board members should be avoided if possible, because again, the public has a right to hear what's going on. I'll digress a little bit. You all remember with the supervisor of elections a year or so ago when we went to their meetings, one of our concerns is you could not hear, and I understand 2 feet away, 3 feet away, we couldn't hear what was being said. So that's one reason you have the microphones, and you try to, and the mayor tries to recognize people and talk one at a time so that the public has the right to hear what's going on. You have to give reasonable notice of the meeting. Obviously, the clerk does a great job of making sure there's notice of the meetings. The amount of that notice depends on the facts and the boards involved. You try to give as much of a notice as possible, but if a hurricane is coming up, the coast, that notice might be 10 minutes to convene a meeting in an emergency situation. Normally, notices are more than 24 hours, though. An agenda and all agenda items are not required to be noticed. You'll notice on every commission meeting there's matters that get added to the agenda or deleted from the agenda. So you can add things even during the meeting. Again, under that theory that, when the public knows this body's in session or any body's in session, they have to be aware of the fact that anything could be added at any point for a discussion. Minutes have to be recorded and made available for inspection. There's no requirement as to the content of the minutes. In other words, they could be very extensive, they could be very brief, as long as they fairly reflect what occurred. And draft minutes prior to official approval are available. So, for example, in your agenda book tonight, there are draft minutes. They are open to the public. Once you approve them, obviously they then become official minutes, but at this point they are a public document. In 2013, the law was amended to add a requirement for public participation, which means the public must be provided with a reasonable opportunity to be heard prior to final action, not at every stage in the process. As you know, you make a motion, you discuss things, and then you have a certain point where the public is heard. And particularly on the consent agenda items now on your agenda, you always have a place for the public to comment before consent agenda items are approved. That's probably the biggest practical change. Reasonable rules of decorum still apply. And there's, again, always exceptions. There's emergency. You don't have to have minutes or public comment on the approving of minutes or proclamations, ministerial acts. And quasi-judicial meetings are kind of unique, and you don't really need to have public comment during quasi-judicial meetings unless it's someone who is going to be participating in that meeting. So if they're an interested party, and essentially they're testifying that their due process rights. Voting requirements. So if you're present at a meeting, and when I say you, I'm meaning any board, committee, including the city commission, you have to vote. Now, if there's a conflict of interest, that's when you don't. And in that situation, you're advised, and usually advise the public what the conflict is. There are various forms depending on the conflict that the clerk will have you fill out. And at that point, you disclose your conflict. But unless you have a conflict, you have to vote. This Sunshine Law applies to, obviously, the commission and all the city boards and committees. And we listed all the different boards and committees that comply: planning and zoning, historic resources, bid proposal committees, tree board, financial advisory, EUAB, Library Board, Pension Board, and different retirement boards. Newly elected officials. As soon as you're elected, the sunshine law applies to you, even if you have not been sworn into office yet. You'll see later on, a candidate, it does not apply to the candidate, but once you're elected, that law applies, which is something where I frankly think we, as lawyers that represent local governments, need to do a better job of letting candidates know that. Because if you're running for office, I don't think many candidates that are running for office realize that the minute they win that election and the supervisor certifies the results, that law applies to them. So I think we need to do a better job of statewide letting folks know that. You can't use a conduit to convey messages. So we talked about commissioners not discussing that, and that's going to come before the body, the board, to discuss. But you can't use another person, for example. So I can't say to Commissioner Jones, you know, this is how I feel about this agenda item. Can you find out how Commissioner Smith's thinking about that? And then, you know, basically you become a go-between. The person that's the conduit is just as guilty of the violation of the law as the people who are on the board or committee. You'll see later that also applies to things like emails or text messages or any way. You just can't communicate, whether it's directly or indirectly. And it applies, and I know this came up during the most recent campaign, so we wanted to try and address things that I know have been issues. Neighborhood associations or any other candidate debate. If two or more current board members are present, so if it's a board member that's an incumbent and not a board member present, that's fine. But if two board members are present at the same debate, if there's the risk that they're going to debate or discuss, or people are going to ask questions about something that's going to come before the board, that meeting needs to be noticed. And Mary Lindsay and I had some conversations about that and other neighborhood associations, and everybody was very cooperative in providing that public notice and preparing those minutes, because minutes are always required, and they were very summary minutes, but at least they were minutes that said Commissioner so-and-so appeared and they debated the issues, and then that was fine. And those minutes were then provided to Pam, and she kept them as the official minutes with the other city documents. Such law does not apply to staff meetings. So staff can meet all day long on issues that may come before the commission, and it does not apply to them. Doesn't apply when there's a meeting between either the mayor or a commissioner and the city manager, the city attorney, or staff. So any one of you can meet with any member of staff, myself, Mike, or anyone else, and that's not a sunshine law violation. Also, as I mentioned before, two or more of you can get together as long as you're not discussing matters that have come before the board. So meals together, travel together. You travel to Tallahassee with Palm Beach County Day in a car together or on a plane together. You attend an event together. All back to the neighborhood association. Attending it is fine. It's the risk of discussing something that's going to come before the commission where the problem is. So avoid it. If inadvertently a fellow commissioner starts bringing up something that you think's not appropriate, just stop them and say, whoa, whoa, sunshine law. And if they continue, walk away. Because again, no one, I don't believe anybody intentionally violates any law, hopefully not, certainly not an elected official violating the sunshine law. It does not apply to purely fact-finding activities. So if members of a committee, for example, are going out there and gathering information, however, this board, as the final decision-making board, cannot do this anymore. It used to be, for example, I know Milwaukee, apparently a few years ago, was a big place to go for code enforcement issues. They had some model code enforcement. But if you're the final decision-making board, you cannot now go up there on a fact-finding mission with more than one commissioner. So now, if that happens, it's a commissioner and a staff member usually. But committees can still engage in purely fact-finding and gathering. Candidates for office, again, that's okay until you're elected. It doesn't apply then. And a member of different boards, so commissioner, city commissioner can meet with a member of the planning and zoning board. That's not prohibited. There are various exemptions. They're created by the Florida legislature. The exemptions are strictly construed. So in general, the sunshine law in the lawyer world is considered broadly interpreted. So when in doubt, figure the sunshine law applies, and if there's an exemption, figure it's going to be looked at very narrowly. One of the ones that I know the public hears us announce a lot up here, is a closed session on pending litigation. So if there's actual litigation pending, not the threat of litigation, not the possibility of litigation, but actually litigation pending, then the attorney would request in a public meeting that I need to have a meeting with the commission to discuss settlement negotiations or strategy relating to litigation and expenditures. The law specifies who can attend: the commission, manager, attorney, and the court reporter, and that's it. I've had, many times in the past, other cities, can the finance director attend? Can the department head attend? And the answer is no. I mean, the law just says who can attend, and that's the only people that can attend. And then there's a transcript made of everything that's said at that session, and that becomes a public record once the litigation is over. Collective bargaining is another exemption, where when you're engaging in a strategy session, again, it's limited. The city manager, the city attorney, and the city commission can attend to discuss what's the strategy. And think about the reason behind these exemptions. Back in the litigation world, when I first started out, the opposing lawyer would be sitting in the front row when I'm sitting up here saying, here's our litigation strategy. Should we settle for $100,000 or $50,000? Well, you have no negotiating leverage at all because the other person is sitting there knowing what can be done. So that's why the legislature created some of these exemptions. Competitive solicitations, some of the exceptions are when you're having a discussion with the respondent, when a negotiating strategy meeting of an evaluation committee, and those must be recorded. And again, once the process is done, that becomes a public record. If there's a concern about a possible violation, the law does allow for what's called a cure of the violation. So you believe that maybe a violation occurred, you would publicly say, Commissioner Jones and I were at a meeting, and by mistake we talked about something. You discuss what was talked about. You lay it out there in the public. Nobody's perfect. People are going to make mistakes. Come forward with the mistake, disclose it, and then you have the meeting, and then you can take independent and final action. Probably the lead case on this is maybe 30 years ago, the town of Palm Beach approved something, I forget what it was, and it was determined that that meeting itself had somehow been a violation of the Sunshine Law. So they had to have another meeting. And it can't just be a rubber stamp meeting. They actually have to go through the process again and consider and deliberate if that body made an actual decision in a Sunshine Law violated meeting, which again is rare. And so a cure meeting is not a guarantee fix, but it usually does resolve any mistake that may have been made. You violate the Sunshine Law, it is technically a crime. It's rare, but here in Palm Beach County, I think we're all familiar that the city of South Bay a couple of years ago, 3 of those elected officials were removed from office by the governor, and 2 pled guilty and 1 went to trial and was convicted. So it's a serious offense. It's subject to a fine, and also civil action where the city could be sued and have to pay the other side's attorney's fees and costs if the city loses a Sunshine Law case. And that little Latin word there, void ab initio, just means it's void, it didn't happen. So if you took a vote today that all these coffee pots are going to turn from black to green, guess what? That vote didn't count at all. It's as if it didn't happen. It's one of those do-overs. And so that's really the Sunshine Law in a nutshell. I don't know, Madam Mayor, if you want any questions on that, if you want to just move into the public records presentation. Keep going, all right? Pam has to reload.